Hi, everybody. My name is Denise Harlow. I'm CEO here at the National Community Action Partnership, and I'm glad you're with us here today. We've been offering a series of webinars over the last few months as community action agencies, state associations, and others have had to navigate some changing waters, right? It is an interesting time to be in the work and maintaining compliance, maintaining our integrity, maintaining the work that we do, and doing what we do really, really well is so critically important for community action every day and in these interesting times. So we are, again, glad you're with us here today. And today's webinar is co-sponsored by and brought to us by the professionals and leaders and colleagues we have over at Wipfli. Many of you know the team over at Wipfli, and they are great partners of us here at the National Community Action Partnership. We're a diamond sponsor for our 60th anniversary year last year, and are stepping up this year as a sponsor of our events. And we just really appreciate all the great work that Wipfli does. And I know many in this network, when you're turning to those groups who have expertise with large, sophisticated nonprofit organizations that have government funding, that's Wipfli, right? And so today we're focused on HR. And today we're going to be talking about navigating HR compliance amidst all of the regulatory shifts we're seeing. It is a complex moment. HR is always a complex issue, if you ask me. It's the thing that can trip us up as community-based organizations, as community action agencies. So I'm going to turn this ball over to Ryan Peasley, who's a partner at Wipfli. Ryan and I have known each other a long time. And Ryan, thank you again for your partnership, your support, and thank you so much for being with us here today. And I'll turn it over to you to introduce our speaker here today.
Yes, thanks, Denise, and thanks to the Community Action Partnership Network here for joining us today. As Denise mentioned, there's a lot of changes that have happened, and that's stemmed a lot of questions coming to Wipfli as of late. And we just thought it was worth getting together here and trying to get answers to those questions. So that's what our esteemed speaker here, Amanda, my colleague here at Wipfli, is going to talk about with this session. There will be some questions naturally that come up. Pop those into the Q&A panel, and we'll do our best to address all of them towards the end. Amanda, go ahead, introduce yourself to the group here, and take it away.
Awesome. Thank you so much, Ryan. So nice to be with you guys here today to talk about all of these things that we're juggling in today's environment. But I'm Amanda Erickson. I've been with the firm for over 2 years now, and I specialize in all things HR. So I have the privilege of working with our community action partners every single day as they navigate these types of HR related concerns, issues, all sorts of things. So it's a privilege for me to be able to talk to you today about such an important topic. We're all trying to navigate everything. Every single day is a different story, a different thing coming up. So as we talk today, like Ryan says, don't hesitate to drop any questions that you might have in the chat, because we're all facing these uncertain times. And one day we'll be able to stop saying uncertain times, but that day is not today. So we're going to go through our learning objectives here quickly. First, I want to start by breaking down the executive orders, very high level, of those specifically that impact human resources today. I also want to address the proactive approach that we can take as HR practitioners to compliance as we navigate these uncertain times. You know, we want to make sure we're adhering to any regulations, but we don't want to do too much before anything's official. So we're going to kind of talk about that balancing act and how we can navigate those. And then finally, we're going to talk about any changes that may shape the future of HR practices that, you know, may or may not happen. We like to talk about the what ifs so that we're prepared. But some things that, based on the current administration, how we can foresee things changing for the future that may not be today, but could be coming. Just an important thing to note, I'm not an attorney, nor do I play one on TV. So it's important to note that the topics that we're talking about today is evolving, it's changing. Tomorrow there can be new developments that totally change our path forward in this area. So make sure that we take this on a holistic approach, looking at even our state levels. States can have different laws that already contradict the executive orders that are in place today. So it's important to make sure that if you feel that your situation may be more complex or you need further guidance, that you engage with legal counsel as you see appropriate. So first, let's start with understanding the executive orders. These are going to be specific to those that are impacting human resources. So these formal directives from the president are going to impact how we do our jobs, and they may impact some human resources policies, infecting employees and our workplace practices. So starting first, on January 22nd, the president issued the executive order titled Ending Illegal Discrimination, and Restoring Merit-Based Opportunity. So it stated that the purpose is to end illegal diversity, equity, and inclusion, DEI as we know it, in the workplace. Now, the definition of illegal DEI is still not defined, but it impacts these three areas very directly. So if we look at federal contractors, this new executive order is going to bar them from considering race, color, sex, sexual preferences, religion, or national origin in their employment, procurement, or contracting practices in ways that violate the nation's civil rights laws. So this means the way it was written, that these programs should immediately cease promoting diversity, holding contractors and subcontractors responsible for taking affirmative action, and allowing or encouraging workplace balancing based on race, color, sex, sexual preference, religion, or national origin. So these federal agencies are going to be having specific requirements as it relates to their contracts or grant awards that require them to comply with these anti-discrimination laws. Now, as of now, the order does not provide more detail on what this looks like. It also does not provide that definition on what illegal diversity is. And it's also extremely important to note that nothing has changed with the existing law as it relates to the discrimination in contracting, employment, or there otherwise. Rather, it's signaling that there are a direct focus from the administration on those that are violating existing anti-discrimination laws in their current employment practices. So while there is a direct target to a lot of diversity and equity and inclusion programs, there is no exact change to the law in the way it is written. So while these things are targeting DEI programs, and we need to look at our DEI programs, which we're going to get into, nothing has really changed in the way the law is written. So, we're going to make sure that as we look at this specific executive order and those that are, federal contractors or receiving grants or financial assistance, that we look at our affirmative action in diversity, equity, and inclusion type policies. Federal contractors are going to be required to certify that they do not operate DEI programs that violate federal anti-discrimination laws. So this is a new component, certifying that you do not operate DEI programs that violate federal anti-discrimination laws. The Attorney General is also going to be identifying those organizations that have egregious DEI practitioners. So this is kind of going to that broader definition of illegal DEI and what that looks like. When we think about the private sector, while there is no definition of what illegal DEI is, this goes across the board, federal contractor or not. We're going to need to look at what our policies state and how they are impacted by this word illegal discrimination and DEI. So anything that references those terminologies, anything that may be looked at, like it could be making different programs within your agencies as it relates to DEI, not fair or balanced, we'll want to take a look at those. The Trump administration has indicated that its objective is to go beyond reinforcing Title VII. For example, the executive order broadly paints that all DEI policies may be unlawful, corrosive, or have some sort of spoil of the system and the way it was intended to work. So this gives us the impression that additional rules and regulations around DEI may be to come. So there is a huge impact for this executive order alone on employment practices. We need to look at our DEI initiatives, our policies, our procedures, and then our overall commitment to equal employment opportunity and non-discrimination within our organizations. How is that written? How is that policy stated? So first and foremost, we're going to be addressing and looking at how we can proactively be prepared for the next phase of what DEI entails. Next, talking about the executive order as it relates to gender ideology. So on the first day in office, the president acted swiftly to ensure that federal agencies recognize only two sexes, both male and female, and to reject this concept of gender ideology. The executive order stated that the purpose is to keep women safe from men who self-identify as women and gain access to intimate single-sex spaces and activities designed for women's, their protection, if you will. And I'm just reading the executive order as it's written, not a personal opinion of any sort. The executive order describes gender ideology as a false construct that replaces the biological category of sex with an ever-shifting concept or self-assessed gender identity, permitting the false claim that males may be able to identify as females and vice versa. So this also includes the idea that there is a spectrum of genders, that there is, some sort of inconsistency between the male and female gender, right? So when we see this specific executive order, they want to make sure that all federal agencies are only recognizing those two sexes, male and female, okay? Then the order applies to other federal agencies and have other, directives as it relates to how that might impact those federal contractors or recipients of federal funding as it relates to this, and maybe services that are offered that relate to this. All employers, though, not just federal contractors, must carefully review their policies, practices, with respect to gender. So think about restroom access, keeping in mind that this executive order specifically has several states that require employers to provide restroom access to employees based on their gender identity versus those that are assigned at birth. So if you live in a state that has that, the state, you should follow your state requirements with regards to that. So when looking at the concept and the executive orders around gender ideology, make sure we're taking into consideration any sort of state requirements that may be there. Next, as it relates to immigration, there was a series of executive orders as it pertained to immigration enforcement, increasing the screening of all foreign nationals seeking entry into the U.S., limitations on birthright citizenship, and suspension of the U.S. refugee and humanitarian programs. These three specifically outlined on this slide can have an impact on the way human resources operates, the way that we have different policies set up to talk about employment authorization in our workspaces. So first, the executive order protecting the meaning and value of American citizenship was aimed to confer children born in the U.S. whose mother or father is a lawful permanent resident of the U.S. So no department or agency of the government may issue documents that recognize U.S. citizenship or documents by the state or local or U.S. government to persons when the mother was unlawfully present in the U.S. or the father was not a U.S. citizen. So this is more restrictive than we've seen previously, but it could impact those employees that may be in the United States temporarily under work visas or waiver programs, or students that are working in the United States on various visas. So this is an important component for those employers that may be in those circumstances. Next, the America First Policy Directive to the Secretary of State. This order directs foreign policy to always put America and American citizens first, and I quote. This may be a kind of a secondary type order that is a reinstatement of the Trump administration's first Buy American, Hire American executive order from his first term. So these policies also impact those employment-based visas that I just was talking about. Those businesses or organizations that hire foreign talent could see increased requirements that they must overcome, those hurdles they must get through for those employment-based visas. And lastly, the protecting of American people against invasion. So this offers, a wide range order that impacts us as it relates to work authorization. So in simple terms, I-9 verification and I-9 authorization, collecting of documents for that process could be impacted by the way this is written. They're talking about expediting removal of those people that should not be in the United States legally. So as an employer, we need to be cognizant of raids and investigations that may be forthcoming. So this could impact not only our workplaces as it relates to our employees, but also the services that we may offer in the community action world could be impacted directly by this. HR leaders should be ready for more frequent worksite raids for I-9 enforcement. Failing to meet these requirements can result in significant legal and financial consequences for our agencies. So making these proactive processes, having these things in place that we're going to talk about here today are going to be essential. When we think about a I-9 audit from the respect of someone else coming in and conducting it. So when we think about U.S. Immigration and Customs Enforcement coming into our organization, examining our I-9 forms, which as an HR professional, that sounds terrifying. We don't know what to expect. It doesn't happen every day. So we need to understand that, what is the employer's responsibility in that, making sure that those documents are available. During an audit, they can carry out whatever types of on-site inspections that they want to ensure compliance. So the process can be very in-depth in the weeds of what's happening at the agency. It's important to understand, though, ICE would have to send a notice of inspection. So that inspection would come notifying the employer that they must provide these I-9 forms for their workers by a certain day. And then they can deliver that, though, in person without any sort of warning, should they have reason to do that. Also, with this comes an increase in immigration raids. They can carry out, this raid without any prior notice. So it's important that we understand or we have policies that we know what to do should these types of circumstances arise. So when we think about our employees, maybe the children that are at with our agencies, how we can have policies in place to protect that as we see so many scary situations arise when that occurs. And last but certainly not least, as it relates to the executive orders, while most have been paused at this time, there has been executive orders, as we all know, that have led to a pause or a reevaluation of federal funding for programs or activities that have potentially impacted nonprofits directly as it relates to the grants that they receive and the money coming in. This has a direct impact on job insecurity, layoffs. You know, having that sudden halt or reduction in funding can force us to make difficult decisions. I've worked with a client very recently that went through this, not sure what to do, how to do it. You know, they want to make sure that they're protecting their employees, but also have to do what's necessary for the agency. Obviously, financial strain. It's difficult for a nonprofit who've lost federal funding to replace it, especially to replace it in a short period of time. So this is causing a lot of uncertainty. Reduction of the services that we're able to offer. We play a vital role in providing very essential services to underserved communities, whether that's food assistance, healthcare, social services. These kind of funding freeze can really disproportionately impact the most vulnerable populations. Oftentimes this kind of balance, right, where we have these harder times comes an increase in demand in the services that we provide. So if we have less staff, less money to provide these services, then it can really cause an imbalance. And then a huge economic impact on our local economies when we see these kind of things happen and the ripple effect that occurs within our communities. So all of this to say, and all of this to kind of highlight, there is so much as it relates to these executive orders that are impacting human resources directly. And what do we do next? We have all this information, we understand kind of the foundation. So how can we be proactive in the what's next? What can we do? So first, I recommend conducting a full review of your workplace policies. You know, whether or not we're federal contractors, have federal grants, it doesn't even matter. All employers should do this periodically to make sure that they're in compliance with other laws besides what we're talking about here today. But more specifically, policies and practices with respect to diversity, equity, inclusion, equal employment opportunity, anti-discrimination, work authorization, so your I-9 process, restroom or any sort of gender-related policy. Maybe you have adopted various policies as it relates to gender transitions, misgendering, harassment as it relates to gender, accommodations, or employment authorization. Those kind of policies are first and foremost based on the outcome of these executive orders. Now, all of our policies may touch on various components of that, so it's not to forget that there's other policies that are intertwined with these ones that I've listed, but it is important to review them. We'll also want to review job descriptions and hiring and employment practices so that we know that we're in compliance, which we'll get into that a little bit more in a few moments. We're going to want to reevaluate our DEI programs. Employers should not make rash decisions regarding their programs and initiatives around DEI. We've made a lot of progress. We've done a lot of work in these programs, We don't need to completely scrap everything to make sure we're in compliance with this notion of illegal diversity programs. But we do need to focus on our strategic plan as our guidepost, what policies, programs, and initiatives are instrumental to our organization that we may need to refine or retool. There may be wording adjustments that need to happen to make sure that our policies are compliant, they are effective for that inclusivity of all people. So keep that in mind when we think about different programs that we have. We just want to mitigate legal risk, making sure that we're in compliance with those civil rights laws. Using similar language to the federal laws or your state laws can really help us ensure compliance and that we're not branching out too far. A lot of times we may need to do something that's temporary, removing things from our websites or our handbooks or training materials, but find different proactive ways to still get that same message across that can be in line with our organization's mission. DEI isn't going to go away no matter what happens. We're going to talk about some of that future state, but it's not going to go away. It's going to be a critical component to our organizations, especially in the work that you guys do every single day. So that's going to help us with attraction, retention, employee morale, and strategic decisions. It's kind of up to HR to balance that that need for diversity, equity, and inclusion in the workplace, and making sure that we're staying compliant with the regulations. So keeping a close tab on those changing, evolving requirements is going to be key. When we think about compliance audits as it relates to immigration, we know that the new administration has resumed raids, resumed some audits. So it's important that we get ahead of it. And how do you do that? Conduct your own I-9 audit, making corrections where any violations may be already, identified. Those employees that are not authorized to work, making sure you handle those situations with care, but with likely an attorney to assist you. We also need to make sure we're providing comprehensive training to anyone who may be conducting the I-9 for us on behalf of human resources. There is a distinct document verification process that we go through when we complete the I-9, and if those are not done with full compliance as it relates to both federal and state law, then we could be opening ourselves up to some serious penalties. So really important to make sure that not only do we audit what we currently have, but also we provide training for those who may be conducting or completing the I-9 document. We'll talk about that a little bit more too. When we think about in federal investigations that may happen in the workplace, how can we prepare? I really already talked about, the preparing for the process. What do we do in case this happens? But what can we look at to prepare ourselves for these investigations to ensure that we are, avoiding any legal challenges? We can look at various policies as it relates to recruitment. When I think about recruitment and how we might want to structure that process, I think about an interview that is formal and structured, asking the same standardized questions for all positions that are, all candidates for a certain position, using a rating scale for candidates. So we're responding to candidates objectively, and then we're training our interviews on how best to avoid biases and making sure that we have a good standardized recruitment process. I also think about performance appraisals. So thinking about promoting people from within our organization, making sure we're using a standardized approach to our performance management process, making sure that we're measuring actual job performance, consistency in the evaluation, and using an objective metric, whether that's a KPI a performance goal or a measurable goal that we can have that objective process is really important to make sure that we are in compliance and we won't face any future legal challenges. Keeping detailed records of hiring, promotion, DEI program participation can demonstrate our compliance with any existing labor laws that are impacted by this. So, if someone is hired, all the candidates that were considered, if someone's promoted, all the candidates that are considered, and kind of the phases that you go through in those selection processes, making sure that we have our detailed documentation, as every HR professional will harp on to their populations. So keep that in mind as you navigate, how can we be prepared for any sort of investigation. When we think about I-9 compliance, this is a huge component of what we just talked about. The easiest way to maintain I-9 compliance is to participate in an E-Verify. While that's not something that everyone utilizes, it is the easiest way to make sure that the form is completed accurately and the documents provided are verified for authenticity. So that is one way. But when we think of the Form I-9 and our compliance, as an employer, it does fall on us. The penalties for mistakes around I-9 compliance can be anywhere from $280 to $28,000 per violation. So this is a huge area to invest our time in to ensure compliance. So when we think about this document, and it's already kind of funny how things work, effective April 3rd, there is a new I-9 form that has already been developed. So if you're not already using the new form, effective April 3rd of 2025, you should certainly download that and begin utilizing that going forward. Now, there is not much that has changed with the form. There are small changes to the language as well as the privacy notice on the new form. So there's very minimal that has changed. Nothing as it relates to training or utilizing the form has changed in quite some time. But it's important to note that all of the sections highlighted in yellow should be completed by the employee and all of those in green by the employer. Now, the changes that have occurred on this new form, effective April, are the checkbox in number 4. The language has been changed from a non-citizen authorized to work, as you see it here on this slide, to an alien authorized to work. So this language is a slight tweak, but the new form would be reflective of that new language. And then also on the new form, the List B documentation for a driver's license or ID card has changed the term gender to be replaced with the term sex to align with the updated language that we've talked about. So very small changes, but there is a new document out there that you'll want to make sure that you start using going forward. So now you may have forms that you've used that their expiration date hasn't occurred yet. So some versions out there have a May 31st, 2027 expiration date. Some have a July 31st, 2026 expiration date. And you can still utilize those forms if you have them like an electronic system. It takes time to update those things. But those ones that are unexpired can still be used, but HR should begin transitioning to this new I-9 form as soon as they can. Here is the second page of the I-9 compliance. If you go through an audit process and you figure out that either the form wasn't completed or the appropriate documentation was not provided, then you can do your own internal audit and make those changes, make those resolutions so that you are in compliance. For example, if an I-9 form was not completed within 3 days of the employee's start date, as it is required, you do need to complete the form as soon as possible and include a note as to why there was a delay in completing that. If the form I-9 is totally missing, you cannot find it, it is not in the separate binder where it should be kept or separate file that it should be kept, these should not be kept with the employee's regular file, then you should complete a new I-9 form as soon as possible. So if you discover it yesterday, complete it today to make sure that there is this document on file. You'll include the current date and attach a note as to why the I-9 was not completed and maybe any supporting documentation that you have. If you notice a form is incomplete, meaning maybe something was not filled out or is missing, you can correct any errors that you may see or add any information that was missing, initial that, date it, and make note of that correction. Now, if you find so many errors on a document where it doesn't make sense necessarily to scratch everything out, you can redo the certain section of that form and attach it to the old form. Always retain that old form, and then you can put any new supplementing form with that. I-9 compliance is very important as it relates to the process and what we see in the future that may occur with compliance. When we think about employees' concerns and what we need to do to stay on top of that, of course, employees are going to be very cautious, concerned about what is happening. So we need to have open communication. Also be open to accepting employee feedback, seeking and addressing their concerns can be the first way to get ahead of things that may be bubbling up in the back of their minds. Also offering any sort of system support that you may have, communicating that out. A lot of times people forget about the employee assistance program or mental health resources that you may offer. Just reiterate those, communicate those, and stress the importance of their well-being. Making sure that employees are treated fairly and equitably through this process can be really important as they may be navigating internal conflict as it relates to things that they may be going on personally. I just wanted to also point out that there are various technologies for compliance that can help you as you navigate these ever-evolving, changing systems. So don't forget about tools you may already have. Thinking about your HRIS system, these systems are designed to have various compliance and tracking mechanisms already within them. So don't forget about those tools. There may be risk assessment tools that you can utilize through there where they can point out areas of caution, red flags, especially if you're doing electronic I-9 processing. I've utilized that in the past. And other various tools. There's many different tools out there for compliance that I've utilized personally as it relates to compliance with our employee handbooks and things like that. And then also using partners like Withly to help you navigate these changes and staying on top of those changes. These tools can help us streamline the process, make them, a little bit more manageable as we're dealing with so many different things on a day-to-day basis. When we think about funding uncertainty, it's important to make sure that employees understand what's happening. First and foremost, HR can help with transparency, providing clear messaging, regular updates, and just really that transparent process of what's happening. We're getting information every single day. Sometimes it doesn't feel manageable to just push that out as soon as we get it because it might create more fires than we can actually put out. So making sure we're very intentional about our communication can be really critical. HR can help with long-term planning. What are the future needs of our workforce, market trends, regulatory changes, and what is our overall business goal, and how can we assist with that? Budget optimization, reviewing budgets, working with leaders to identify cost-saving measures, reallocation of resources wherever possible, especially when we start to think about layoffs or furloughs, which we're going to talk about here shortly. How can we reallocate resources before we get to that point, if at all possible? One other piece of information that's important is around the WARN Act. If due to funding, we are required to, needing to lay off or reduce our workforce, it's important that we understand any sort of laws that we may need to be in compliance with. So the WARN Act mandates that employers with over 100 or more employees give at least 60-day notice before a mass layoff that affects 50 or more employees as it relates to their employment. So, if that resonates with you, if you feel like you fall in that bucket, just know a funding freeze can be an exception to the WARN Act where you don't have to provide the notice, but it doesn't automatically mean that it is, that it would be an exception to that. There could be various evidence that's required as it relates to the grant that funds this program and things like that. So it's not an automatic that you wouldn't have to provide that 60 days notice before a mass layoff just because of a funding freeze or any sort of uncertainty around funding. So we need to be proactive and really understand the impact there. But sometimes we're not sure as it relates to a layoff or a furlough, what do we do? And while a layoff technically means a permanent or indefinite termination of employment, it essentially is severing employment under every sort of definition of the word, benefits, any sort of employment-related benefits that come with that are terminated as of the date of a layoff. But the WARN Act doesn't necessarily specify that a certain period of time must pass before a layoff can be rehired. So it is important to note that employers can bring back laid off employees as soon as they're able to do so, but they must comply with all labor laws and contractual obligations that they have. There was, sort of misinformation around COVID versus layoffs and furloughs. But furloughs typically are temporary, unpaid times off for an employee, but they still remain kind of on that company roster. They're still tied to your business, your agency as an employee. They may still get health benefits and other benefits as it relates to being an employee, but there are some states where if you are furloughed, you may or may not get unemployment benefits. A lot of times this can vary state by state, whether or not furloughed or layoff employees would actually receive unemployment benefits. So important to address and talk to an employment attorney before making any sort of decisions as it relates to laying off employees. Never go at that alone. It is not something we want to navigate in a silo by ourselves. So what does the future state look like? And then we'll wrap up and get to questions. Now, these are all just thoughts. This is not absolutely going to happen, but when we think about navigating what's to come as it relates to HR compliance, we're going to want to look at our DEI programs and immigration specifically. I feel that these two areas are going to take the biggest hit, if you will, for compliance and how we can, navigate what HR looks like tomorrow. So, rolling back DEI programs, making bans on DEI metrics. But I certainly and strongly believe that DEI should not disappear. It's going to have to evolve to meet whatever sort of compliance we need to accomplish. And with immigration, stricter criterias as it relates to, who is a citizen and who should be authorized to work in the United States. There is going to be an impact on visa holders as well as employer-sponsored permanent residence application. We already know those are extremely difficult. They are only going to become more and more difficult as the administration strongly believes that, employers should be hiring US citizens. So just kind of to recap, as a takeaway from today, do not sit idle and wait for additional clarity on what these executive orders mean, what turns into, the next action item. Do not wait. We can do these various steps that I've outlined here today to proactively prepare for regulatory changes without doing too much, that we're investing too much time in something that may or may not be. Some of these things are things we should do anyways. We just have to make the time to do them. Also, staying informed, finding ways to get continuous education and updates and regulations through partners like NCAP and WIFLE and CAP law and other resources that you might be able to find. Up-to-date information with your associations can be really important. And then where you feel that is necessary, make sure to engage with legal counsel before things get too tough. Don't wait till the last minute. Legal counsel can give clarity around concerns to help you minimize risk before it's an issue. And these kinds of things should not be navigated alone. So I definitely recommend getting some partnership there. So certainly not something you want to wait on. But that kind of wraps up what I had to share with you today. I'm sure we have some questions in the chat, so I will ask Ryan to
Amanda,
field
I
those for me.
see. So thanks for going through that. There are a couple questions related to I-9s and then another question around layoffs here. So I'll go through the I-9 ones here.
Sure.
Around I-9s and former employees. How do you handle a missing I-9 for a former employee? And then can an I-9 audit include former employees?
Yeah, certainly. So when we think about I-9 compliance, there is a certain period of time in which we as employers are required to keep I-9s on file. So for example, you must have a completed I-9 on file for each employee on your payroll who was hired after November 6th of 1986. So every employee that you've had since then, and you can never dispose of an employee's I-9 until they have reached the certain period of time that is required, the certain period of lapse that happens after a termination. So with an I-9, you have up to 3 years after the hire date or 1 year after the employment date, when that termination date ends, whichever is later, that you would want to make sure that you have an I-9 on file. Now, that certainly makes it tricky if you discover that your I-9 is not in compliance with a terminated employee, right? So, for example, if you figure out that they're not in compliance, there may be little that you can do about that, because you would have to call that employee and get an I-9 on file, and that would be a complicated situation to navigate. So yes, you'll want to audit your terminated I-9s to kind of see where you're at, know where your risk is, and then you may want to, talk to an attorney if you feel like it's a big enough issue that you have, if you're missing any of those I-9s. Great question, though.
And then the last one here, can you explain the difference between a layoff and a RIF/reduction in workforce or reduction in force? Yep.
Great question. Yeah, the terminology there is really interchangeable. Layoff, reduction in force is really an interchangeable word. So some people use a layoff as a terminology as it relates to kind of the size that it impacts their organization. But those terms can be used interchangeably. There is no real substantial difference in the two. As an employer, we may say reduction in force is part of our policy. You might have a header in your handbook that talks about reduction in force. How you go about it may be a layoff or a furlough, for example. So it's kind of the way that you are reducing your workplace.
That answers all the questions that come in or came in through Q&A. I just wanted to add that, Amanda is, a resource here at Whipfly. I don't know if you had your contact information you wanted to pop into the chat window, for everybody here, Amanda, should they have additional questions that they want to reach out for. Amanda will also be at Whipfly's Stronger to Serve conference. That's going to be July 14th through the 18th at Caesars Palace in Las Vegas. I'll pop in a link into the chat window there. But Amanda, plus many other experts at Whipfly talking about finance, HR, technology, strategic planning, leadership development, and much more are all there. Click on that link to find out more. And then I'll pass it back over here to Denise to round out the final bits of the webinar here. Thank you.
Thanks, Ryan. Thank you, Amanda. Really appreciate you. And I saw it came to internal to the question, so I'm making sure everybody on the webinar has a chance to hear your response. You made mention that the I-9 needs to be kept separate than the personnel file, and it looks like you've confirmed that that is the case. If you want to expound on that a little bit.
Yeah, that's a great question. And oftentimes one of the things that I see is not in compliance is that it's not separate. So if that's you, don't feel like you're the only one, because that is a common issue. It should be separate for ease, right? So if immigration walked in and asked for all of your documents and you had to file through 200 files, it could be a while before you're able to provide that to them. So, and since the retention rate of your employee files and the retention rate of an I-9 document can be very different, we always recommend those should be kept separately in a binder or some sort of file, obviously locked up and separated, but definitely should be separate for compliance purposes.
Thank you for that. A question came into the Q&A window that I think is probably on the minds of a lot of folks. We're employers, we're businesses. The compliance side of the equation sometimes is counter to the heart part of community action. Any advice that you would have as a HR professional, having had many of these uncomfortable conversations and challenges? Any advice you would give to folks who are on the heart side of this conversation?
It's really hard because all of these things, especially what we talked about here today, impact not only us as employers to our employees, but also the people that we serve. So there is, no easy way to approach it. It does require sensitivity and, hard conversations. But I will say, as always, my motto with human resources is putting the human back in the workplace. And so, sometimes we have to do things that we have to because of compliance, but, also leading with our heart, how we would want to be handled in those difficult situations can really make or break that kind of relationship that you have and that reputation that you have within the community. Sometimes we have to do something difficult and it impacts our reputation, but the way we handle it with grace and kindness, just as we would expect our employees to act, on the job every day, can really make a huge difference when you're navigating these hard situations.
Thank you for that, Amanda. Great advice and good to remember. And it is a very challenging time, and to try to keep up with all the different funding streams. And I know we have a number of toolkits at the partnership that we've done as part of this webinar series around scenario planning, for instance. And from an HR perspective, kind of having your plans outlined at least so you know what needs to happen, when it needs to happen, or if it needs to happen in advance is helpful. I see another question has come into the chat. Do you have a copy of the driver's license and social security card in the file with the I-9 or only the I-9 form?
So you can, make a copy and attach it to the I-9. That is okay. As long as it's kept separate and confidentially, that not everyone has access to that document. That is okay. I've seen it kept separate as well, where you keep the documents, but then if there's any sort of, investigation further, you have to dig those out. But the document itself is what is required to be kept separate.
And does that go to that follow-up question in the chat around maintaining hard copies in addition to electronic copies?
Yeah, that's a great question. And we're still in this weird space with documentation and electronic. I will say though, if the I-9s are easily accessible electronically, so for instance, you could print them all in a batch or they're easily accessible. I would say no, you don't need to also keep a hard copy of that. I am adamant that I hate paper, so I'm not going to recommend that you have to have paper. But if they are difficult, if it would take you hours to pull them, then you may want to consider how you keep that on paper too, so that you have kind of both. But then, keeping track of two sources of documentation can be difficult too. You got to weigh your pros and your cons there, but not required if you can access them electronically.
Thank you. Well, I do think that clears both of our queues of questions, so thank you for your flexibility on that. And as Ryan mentioned, the Stronger to Serve conference for Whitfleet is this summer in Las Vegas. The Partnerships Convention will be in Detroit at the end of August. Registration for that is open. And those, how those hotel reservations go for both events. So encourage you to think about that. And just a shout out to Cap Laws as well at the end of May. So and sometimes being together in these moments and being able to share the real life stories. Also want to flag for the group executive directors, we are having a series of town halls. The first one starts later today and we'll be doing them next week as well, for EDs to have kind of a convening space to have some conversation. So I just wanted to flag that as well. So thank you so much for being here today. Amanda, really appreciate your expertise, the care you brought to this information. It's not the easiest all the time, and really appreciate your real world experience. And thank you everybody for being part of this. We have another webinar, I believe, later this month alongside with Whitfleet. So we'll just keep providing. If there are things that you need as organizations during this time, please don't hesitate to ask us. We have the great partners with Whitfleet and CapLaw and K-Sol and others. And at RMC, we're able to develop tools and resources that you need, but we need to know from you what you need. So please always send that along. All right. Ryan, Amanda, any last comments before we say goodbye?
No, thank you so much.
Yeah, just thanks everybody for showing up and listening in. And we know that road is windy. I guess the next few months here, maybe longer, and we're here in it with you, as Whitfleet has been for the 40+ last years that we've been working with national community actions. So thank you again for your time here this morning or afternoon, wherever you're from.
Great. Thank you, everybody. Oh, there is an evaluation in the chat as well. That'll give you a chance to tell us what we need to do to better meet your needs. So please don't hesitate to follow up with that. And thank you, Juanita. We will see about grabbing your email address as well and add you to the list. All right. Thanks again, everybody. Community action keeps changing people's lives. Keep at it. We know you are. So have a great day. Bye-bye.